There is a specific reference to the registered document under which the appellant purchased the suit building from the earlier landlord in the plaint. Yet, in the written statement, the respondent denied the title of the appellant. We notice that there are several documents on record relating to the ownership of the appellant apart from the registered sale deed, such as municipal tax receipts, ration card, etc. Yet, the respondent refused to acknowledge the appellant's title. He denied it in his evidence. This is not a simple case of denial of derivative title by a person who did not know about the purchase of the building by the landlord. Even after going through the relevant documents relating to the appellant's title, the respondent feigned ignorance about it. The High Court has accepted that in his cross-examination, the respondent has stated that he was not accepting the appellant as his landlady. The High Court has, however, gone on to say that by this piece of evidence, no decree of eviction can be passed against the respondent under section 12 within bracket 1 within bracket small c of the MP Act, because the respondent will have to no occasion to establish in what circumstances he denied the title of the appellant. The High Court has further held that the respondent was within permissible limit in asking the appellant to produce documentary evidence about his title as a landlord. The High Court, in our opinion, fell into a grave error in drawing such a conclusion. Even denial of a landlord's title in the written statement can provide a ground for eviction of a tenant. It is also settled position in law that it is not necessary that the denial of title by the landlord should be anterior to the institution of eviction proceedings. Para. The High Court has expressed that the respondent has justified in asking the appellant to produce the documents. Implicit in this observation is the High Court's view that the respondent could have, in an eviction suit, got the title of the appellant finally adjudicated upon. There is a fallacy in this reasoning. In eviction proceedings, the question of title to the properties in question may be incidentally gone into, but cannot be decided finally. Similar question fell for consideration of this court in Devaki Nandan. In that case, it was argued that the landlady was not entitled to inherit the properties in question and hence could not maintain the application for eviction on the ground of default and subletting under the AP Tenancy Act. This court referred to its decision in Tej Bhan Madan versus 2nd Additional District Judge and others 2011 9 SCC 444, in which it was held that a tenant was precluded from denying the title of the landlady on the general principle of estoppel between landlord and tenant, and that this principle in its basic foundations means no more than that under certain circumstances law considers it unjust to allow a person to approbate and reprobate. Stop.